Right. Hi, everyone, and thank you for being here. Welcome to our Human Rights in Practice event, Protest in Times of Crisis, which is organized by the Center for International and Comparative Law and the International Human Rights Clinic. We also have several co-sponsors for today's event as well, including the ACLU Student Group, the Human Rights Center at the Franklin Humanities Institute, the Environmental Law Society, the Human Rights Law Society, and the International Law Society. And I'm very excited to introduce our three speakers, and I'll introduce them in the order in which they'll speak today. So first we have Deepa Padmaba, who's the Deputy General Counsel for Greenpeace USA. She's been with Greenpeace since 2011 and is based in Washington, D.C. Prior to joining Greenpeace, Deepa worked at a law firm and focused on whistleblower suits against pharmaceutical companies. This is on defending Greenpeace against two lawsuits attempting to silence the organization's advocacy work. And she also advises on a variety of legal matters and manages criminal law cases on behalf of environmental activists who engage in peaceful civil disobedience to promote systemic change. We'll then hear from Christy Gronke, the legal director of the ACLU of North Carolina, where she leads litigation and other legal advocacy to advance and defend the rights of North Carolinians under federal and state constitutions. Before joining the ACLU of North Carolina in 2020, Christy worked as an attorney with the Southern Poverty Law Center, where she focused primarily on enforcing the civil rights of low-income immigrant workers in the southeastern United States. In 2015, she received Public Justice's Trial Lawyer of the Year award as part of a team that tried a human trafficking case to a $14 million verdict for the plaintiffs. Prior to working with the Southern Poverty Law Center, Christy was an Equal Justice Works Fellow with the Farm Worker Division of Georgia Law Services. And finally, Leo Rabasa, who is joining us virtually, works as a legal advisor in Amnesty International's Global Law and Policy Program in the Civic Space team. She has spent the last 15 years focusing on human rights, many of those years working with human rights defenders and activists across regions, specializing in security and protection, advocating against criminalization and undue restrictions of their rights and legitimate activities, and for the advancement of human rights standards relevant to the defense of civil space. Leonor joined Amnesty almost 12 years ago and has worked in a variety of roles, some with a global scope and others regionally in the Americas, Europe, Eastern Europe, and Central Asia. Before our speakers get started, just to note what a timely topic this is, giving really growing and intensified threats to protests globally. And we're looking forward to discussing this issue in a number of different contexts. So Deepa will start us off by discussing SLAPP suits, or strategic lawsuits against public participation, that have been used to target environmental groups, including Greenpeace. Christy will discuss ACLU North Carolina's suit challenging various provisions of North Carolina's Anti-Riot Act. And Leo will discuss Amnesty's global Protect the Protest campaign that was launched in July of last year to confront states' widening and intensifying efforts to erode the right to protest. With that, I'll turn it over to Deepa.
Thank you. It's really wonderful to be with you all today. So since 2016, Greenpeace has been entangled in two massive lawsuits that seek to silence our advocacy work, bankrupt us, and ultimately destroy us. Lawsuits like these attack our First Amendment rights to free speech and assembly. And there's actually a name for them, SLAPPs, or strategic lawsuits against public participation. And SLAPPs are a growing threat to organizations, activists, and really everyday people who seek to protect their access to clean water and clean air. And the goal of filing a SLAPP is not to actually win in court. The goal is to silence and scare people into silence. So Greenpeace's journey in the world of SLAPPs began in 2016, but instead of starting there, I'm going to start with a recent victory because I don't think we celebrate our victories enough. So in April of this year, Greenpeace defeated a 7-year SLAPP suit filed by Resolute Forest Products, which is one of Canada's largest logging companies. And the company had sued us for $100 million after we launched a public campaign challenging the company's destructive forestry practices. So in April, we had oral arguments on our motion for summary judgment, and just one day later, the judge granted our motion and dismissed the remaining claims. Unsurprisingly, Resolute has appealed the decision to the Ninth Circuit because that is, part of the process of a SLAP. But it's important just to remember that this was really a true victory in protecting our right to speak truth to power. Along with this victory, there have actually been some wins along the way. So this is when I'm going to go back to 2016. Because in 2016, this is when these companies first came after us with RICO. And yes, that's the Racketeer Influence and Corrupt Organizations Act, which many of you probably know is a set of laws designed to go after the mafia. And they didn't just come after us with RICO once, they came after us twice. So first in 2016, it was Resolute. And 1 year later in 2017, it was Energy Transfer, which is the company behind the Dakota Access Pipeline. No coincidence, these suits were very similar. They were both filed by the same law firm. And what these companies were trying to do was equate our right to speak out against their destructive practices with work for organized crime. A very scary moment, but we really confronted those claims head on. And with tremendous support of our allies and incredible work of our counsel, we did get RICO thrown out of both cases at the motion to dismiss phase. And this was really big. Groups across issue areas were deeply concerned that RICO was going to be the new tactic used to destroy movements and our ability to work with one another. And so with these wins, there is now legal precedent on the use of RICO against advocacy organizations, and we have shut down what could have been one of the biggest threats to organizing. Unfortunately, though, our fight didn't stop there, and that's what I'm going to focus on today. So Energy Transfer and the fossil fuel industry recognize the power of the resistance at Standing Rock. And that is why they're putting everything they can into destroying our ability to speak out, organize, and protest. So even though we did get RICO thrown out, we still face a $300 million lawsuit in North Dakota State Court, where Energy Transfer alleges that Greenpeace orchestrated the entire resistance movement at Standing Rock. So I think probably most of you are familiar with Standing Rock, and we all know that it was an indigenous-led movement. And what Energy Transfer is trying to do is rewrite history. What their narrative is that Greenpeace is a criminal enterprise that went into Standing Rock with the intent of training violent protests. And the company intentionally chose to file this lawsuit where the protests occurred because there is still a lot of emotion surrounding the protests at Standing Rock. There is a high degree of hostility towards outside individuals and organizations who they often label as outside agitators. And there's a feeling that they want somebody to be held accountable, and Energy Transfer wants this to be Greenpeace. Very clear that the intent behind this lawsuit is not just to destroy Greenpeace, but it is to destroy the movement and our right to protest. So to do this, Energy Transfer is trying to create dangerous law around protest liability. And their argument is that any trainer at a protest should be held responsible for the actions of every person at that protest. So in other words, a trainer who teaches principles of de-escalation, of safety, and of nonviolence should be held responsible for the actions of an unknown protester who, for example, sets fire to construction equipment, uses Molotov cocktails or other violent means. And this is actually not the only place where we are seeing these attacks. There's another case in Louisiana involving the organizer of a Black Lives Matter protest. And this organizer, his name is DeRay McKesson, organized a nonviolent protest. And at that protest, there was an unknown individual who threw a rock that hit a police officer. And that police officer is suing McKesson, attempting to hold him liable, arguing that the throwing of a rock was reasonably foreseeable in a nonviolent protest. It is no coincidence that we are seeing these attacks in Indigenous and Black-led movements, and it is also no coincidence that these are the movements that are primary targets of new anti-protest legislation seeking to enhance criminal penalties for protest activity. So for several years, Greenpeace has been fighting these cases tooth and nail because we have to. Our very existence is at stake. But we know that we are not just fighting this for us. This case has huge implications for the movement. And we have to find a way to show corporations that this is a losing tactic so they won't think twice about going after other individuals and organizations. This is really a test case. So what SLAPs do is they really put a price tag on speech. And one of the most effective ways that we can remove this price tag is through the passage of both federal and state level anti-SLAP legislation. So right now there are 32 states that have anti-SLAP legislation along with the District of Columbia, but there are still 18 states that don't have it, including North Dakota, and there is no federal anti-SLAP law. So the mere filing of a SLAP often has the effect of silencing speech because one, it often takes years of significant legal costs to finally prove that a case lacks merit. And two, there is no financial deterrent for those with deep pockets to file a SLAP suit. And so what an effective anti-SLAP law does is it addresses both of these issues. First, it provides a mechanism for the case to be thrown out earlier on, preventing parties from going to the discovery phase, because it's really discovery that is the costly part. So an anti-SLAP law provides a special procedure to get rid of the case early on. And then it also forces plaintiffs to pay the defense costs and fees if the case is determined to be a SLAP. So there is a financial deterrent. So what SLAP plaintiffs do now is they engage in what's called forum shopping. So they look to file cases in jurisdictions that don't have an anti-SLAP law. And we at Greenpeace have firsthand experience with that. So in our Resolute case, when the case was originally filed back in 2016, Resolute filed the case in Georgia, which had nothing to do with the case. But at the time, it had a very weak anti-SLAP law. And so what we did is we filed a motion to transfer the case to California, which is the jurisdiction that made sense. But California does have a strong anti-SLAP law. And in California, we were able to recover what is believed to be the largest fee amount ever awarded under California's anti-SLAP law. And so, what does that mean? What does that translate into? It means that a court found that Resolute's claims attacked our First Amendment rights. So it ordered Resolute to pay the fees that we spent defending these claims. What anti-SLAP laws do is it helps level the unequal financial playing field between companies and activists. And while they may not stop these suits from being filed, they do provide a significant deterrent. So if we really want to unclog the judicial system of these meritless claims, we need both federal and state level anti-SLAP laws in every state. So I just want to end by reminding everyone that SLAP suits are really driven by fear. We are winning, our movements are growing stronger, and these corporations are feeling the force of people power. This is all happening at the same time that climate litigation is actually on the rise. Big oil is being taken to court for lying to the public about what they have known for decades about the industry's role in climate change, for engaging in fraud. And so what they're doing is they're launching these preemptive legal attacks to control the narrative, where they accuse their critics, like Greenpeace, of engaging in fraud to avoid accountability. That is really at the root of most SLAP suits. So the most important thing that we collectively can do at this moment is to make our movement stronger, louder, bolder, and more effective than ever. We are fighting the legal fight in the courtroom, but there is also a movement fight that we have to win. And we need all of you. We need all of you to bring visibility around this fight, to take and support actions that protect our communities, that protect our planet. And we need you by our side when Greenpeace and the movement go on trial next July in North Dakota. Because it really is through our collective action that we will send a message to these corporations that we will not be silenced. Thank you.
Okay. Hi, again, I'm Christy Grunke, and I'm the legal director of the ACLU of North Carolina. And our mission is to defend the rights of North Carolinians under the federal and state constitutions, and this includes policy and advocacy work, for example, working in the General Assembly to try to prevent the passage of unconstitutional laws or urge reforms that we believe are important, but also litigation. So when the General Assembly passes laws that we believe are unconstitutional, we sue. And we work in a variety of areas, including freedom of speech and assembly, racial justice, challenges to inequities in the criminal legal system, LGBTQ rights, and reproductive freedom. Obviously, today we're focusing on free speech and association, and so I want to talk about our litigation challenging portions of HB 40, which was 2023, the 2023 General Assembly's amendments to an existing law in North Carolina called the Anti-Riot Act. And the Anti-Riot Act actually has a long history. It was first passed in 1969, and we all know what was happening in 1969. This was clearly a response to mass protests that were happening in response to the Vietnam War, in advocacy for civil rights, protests, sit-ins at universities and in businesses. And the Anti-Riot Act was a package of legislation that the General Assembly passed to crack down on protests. For example, in addition to the Anti-Riot Act itself, there was an act to increase punishment for demonstrations or assemblies of persons kneeling or lying down in public buildings. There was an act to restrict access to university campuses and regulate use of sound amplification devices on university campuses. And this was part of a larger national trend of states and federal government, actually the federal government passing this kind of legislation in response to mass protest movements. At its core, the Anti-Riot Act criminalized engaging, inciting, or urging a riot. And a riot is defined under the statute as a public disturbance involving an assemblage of 3 or more persons, which by disorderly and violent conduct, or the imminent threat of disorderly and violent conduct, results in injury or damage to persons or property, or creates a clear and present danger of injury or damage to persons or property. The Anti-Riot Act of 1969 was basically in place, pretty much untouched, for 50 years. We come then to the summer of 2020, and widespread mass protests as part of the Black Lives Matter movement all over the country, especially after the May 2020 murder of George Floyd in Minneapolis by police. Here in North Carolina, we saw racial justice protesters in Charlotte trapped, kettled, and tear-gassed by the police. We saw activists who were protesting a Confederate monument in Graham, North Carolina, threatened with arrest for their lawful protest in a public space. In October 2020, we saw peaceful marchers to the polls, again in Graham, North Carolina, who were going to vote in the early voting period, forcefully dispersed with pepper spray and arrested. And this is just to name 3 cases that the ACLU of North Carolina was involved in. There were other examples of mass protests, which were sometimes met with police force and curfews and other efforts to limit those protests throughout the state. So turning to the 2021 legislative session, the General Assembly, like many legislatures around the country, responded to the summer of protest of 2020 by proposing a bill that would enact stiffer penalties for so-called rioters, as well as more onerous conditions on pretrial release that would effectively prevent some arrested protesters from being released in time to be able to rejoin protests, and would bar them from being able to enter specific areas where while their charges were pending. The General Assembly made its first attempt to in the Anti-Riot Act to add these provisions in the 2021 session. They cited the Black Lives Matter protests that occurred over the past year as the main impetus for this bill, and referred to the protesters as, quote, ignorant thugs, vermin, and a lawless, godless mob, Marxists, and, quote, not true Americans, unquote. So these are some of the quotes coming from some legislators at that time. Governor Cooper vetoed that bill, and the General Assembly did not have the votes to override his veto at that time. Now we come to the 2023 legislative session, and this legislative effort was renewed this spring in the form of HB 40. And this time the General Assembly did have the votes to pass this law over a potential gubernatorial veto. As it happened, the governor did not veto it. He didn't have the votes to sustain a veto, but did not sign it either. So it went into effect. And although harsher penalties for rioting and limitations on pretrial release are really the meat of the bill, The bill reiterated the old definition of riot that had been in existence since 1969 and also doubled down on language that criminalized not only engaging in riotous activity, but, quote, urging a riot, and added an additional prohibition against urging a riot that results in someone's death. This repeated and added urging language was noteworthy for two reasons. The first is that in 1969, that was the year when the original Anti-Riot Act was passed, the Supreme Court decided the case of Brandenburg versus Ohio. And in that case, a Ku Klux Klan leader who gave a speech urging violence against Black people and Jewish people had been arrested for violating an Ohio law that made it a crime to, quote, advocate the duty, necessity, or propriety of crime, sabotage, or unlawful methods of terrorism as a means of accomplishing industrial or political reform. Now, I want to acknowledge the complexity of some of our most important First Amendment precedents here. Many of them do involve hate speech, and they are difficult to visit and read, particularly in light of what is still going on today. But Brandenburg has turned out to be a very important case because there, the Supreme Court overturned Brandenburg's conviction and unanimously held that there is a First Amendment right to advocate violence so long as the advocacy is not, quote, directed to inciting or producing imminent lawless action and is not likely to incite or produce such action. So if speech is directed to inciting or producing imminent lawless action and it's actually likely to cause such action, it can be punished. But there are some lines there and some limitations to when simply advocating violence can be punished that were created by Brandenburg. And this case arguably should have had the effect of invalidating portions of the 1969 law that criminalized merely urging a riot. Yet when the legislature enacted HB 40 in 2023, they reiterated that old language, urging a riot, and added a new urging offense. And in doing so, they were contradicting not only Brandenburg, but also crystal clear 2020 precedent from the Fourth Circuit in Marcellus versus United States, where the court held that a parallel provision of the federal Anti-Riot Act that criminalized urging a riot was unconstitutional under the First Amendment and Brandenburg's reasoning. So you may say, well, maybe the General Assembly didn't know about Brandenburg or Marcellus before they passed this law. Well, they did. We told them about it. We and other coalition allies wrote them a letter explaining the constitutional issues that we spotted in HB 40, yet they went ahead and passed this law. So we sued. In April, we filed suit in U.S. court for the Middle District of North Carolina, challenging two aspects of the Anti-Riot Act. The ACLU of North Carolina is the plaintiff, and we're suing on behalf of our members and also ourselves because our members and employees frequently engage in protests around the state and have a credible threat of prosecution under this law. And so first, we talked about, we challenged the urging provisions, as we call them, as clearly violating the First Amendment, and we also said they violated the parallel North Carolina constitutional provisions, Article 1, Section 12 and 14, citing, again, Brandenburg and Marcellus. Second, we actually challenged the old definition, the longstanding definition of riot, as overbroad in violation of the First Amendment and the same parallel provisions of the North Carolina Constitution, and as vague in violation of the 14th Amendment's Due Process Clause and the North Carolina equivalent, which is Article 1, Section 19. And our argument here is that the definition's language, which sweeps in any member of an assemblage of 3 or more persons engaging in disorderly or violent conduct, doesn't specify that each member themselves of that assemblage must have participated in the violent or disorderly conduct to be convicted. In other words, it posed the danger of somebody being held liable merely by association, merely by being present where somebody else might be acting violently. You mentioned DeRay McKesson. This is exactly the problem of somebody who's an organizer or participant in a protest being held liable for the acts of other people at the protest. And there is a Supreme Court precedent on this, a happier set of facts, NAACP versus Claiborne Hardware, which held that the NAACP, whose Secretary Charles Evers, this is a Mississippi chapter of the NAACP at the time, the secretary had given a fiery speech to people who were boycotting stores whose white owners refused demands for racial equality. And the court held there that that Mr. Evers, that the organization of the NAACP could not be held liable for acts of some boycotters in threatening violence. And the idea there is that even if the argument was made that the state was arguing that some leaders of the NAACP had encouraged this violence, there was no guilt by association for the association and its members unless individuals themselves had participated in that violence or those threats of violence that could be conceivably punished. So that's a very critical case, and I think that's one of the examples of being a First Amendment lawyer and having an opportunity to look at these precedents that are incredibly profound and meaningful and document the history of the civil rights movement in a much better way than I think Brandenburg, in terms of just recognizing that this body of law is very complex and contains multitudes. And I have to give a little quote from this case. Justice Stevens, who was writing the opinion, wrote that the boycott of white merchants in Claiborne County, Mississippi, that gave rise to this litigation included elements of criminality and elements of majesty. And so if anybody wants to start a First Amendment law journal called Criminality and Majesty, I will subscribe to it. I just thought that was a really nice quote there. But just quickly to wrap up, shortly after we filed suit, the General Assembly enacted legislation stripping all the prohibitions criminalizing urging a riot from the Anti-Riot Act. So it was a partial victory, but just by standing up and pushing back and suing, and this doesn't happen often, the NCGA backed down, and we let them know that we are not going to accept plainly unconstitutional legislation. However, they didn't change the definition of riot, which I think is plainly unconstitutional as well. So we remain challenging that provision as overbroad and vague. The defendants had moved to dismiss. The basis of their argument is largely that they believe that the ACLU of North Carolina does not have standing to sue, but also they think that the definition of riot is best read to require individual culpability for violent activity. So if we were confident that their interpretation would in fact be the belief of every single district attorney from time immemorial, we would be comforted. But in this case, we still think it's broad and vague and susceptible to abuse. So we're going to continue on that challenge. And the court has yet to rule on these motions, so stay tuned.
Yeah. Okay. Leo, do you want to try?
Hello, can you hear me?
Yes, we can.
Oh, that's great.
Yeah, we had a wonderful IT person here who's addressed the problem. Thank you for your patience.
Yes, and thanks to you, because it is a real pleasure to be here. I'm a bit self-conscious about the size of my head on your screen. Supposed to sort of hurts. It's been absolutely fascinating to listen to the other panelists today, because I kind of missed working on a specific country and a specific issue where you get to go really in depth. As I was saying, I work in a global team, in a global organization, and on a global campaign at the moment, and it's quite overwhelming, to be absolutely frank. I prepared a PowerPoint presentation that I'm going to try to share with you. I hope technology doesn't fail me again.
If you're not able to, Leo, I can also share it, but if you do it, you can navigate it yourself. So.
Okay, I'm just going to try to share my screen and see what happens.
Sounds good.
It says host disabled participant screen sharing.
Okay, let me. Out of practice on Zoom.
Should be the share screen.
Oh, thank you. All right, Leo, try again, please.
Okay, I think I've got this. Okay. Can you see it?
Yes.
Okay.
Great, thank you.
Yeah, because you asked me to come and tell you a little bit about Protect the Protest, which is a global campaign that, as you said, we launched last year. I thought I had to tell you a little bit about, Amnesty, because not everybody necessarily knows a lot about the organization very, very briefly. It was founded in 1961, so it's over 60 years old, by a British lawyer. And I'm mentioning the British lawyer element here because it did influence a lot how the organization started and what it was about. It was obviously a white middle-class man in a European country. And I think Amnesty has evolved massively in the last 60 years, not only by expanding the spectrum of human rights that we focus on, but also our regional presence in over 70 countries in the world. The fact that it's a membership-based organization and that gives us, on the one hand, the independence from political ideologies, economic interest, and religious interest, possibly, but also the fact that we are a campaigning organization that is fueled by people power. So we claim to have over 10 million members, supporters. I think that the definition may vary, but the idea behind Amnesty is that we do research for impact, and everything that all the steps that we take to achieve our goals go through the power of mobilization and engagement. And I think it's quite particular about Amnesty. And it also means that we have a very complex governance system because our members can influence opinions. We have general assemblies, and when we have difficult policy decisions to take, our members have a say on that. And sometimes it's particularly challenging. Like, for instance, what we advocated for having decriminalization of drugs as a policy of Amnesty. So it's quite interesting how all this membership element operates both on the positive side, but also in terms of being more complicated sometimes. I also wanted to show you this very, not very friendly or attractive chart where we, Amnesty has this global strategic framework that we work within for our campaigns and our work, and that impacts our policy priorities as well. And it's in this work that operates between 22 and 2013, 2013, that the campaign Protect the Protest was born. And this came basically from, all or the movement, as we call it, of Amnesty, identifying freedom of expression and the civic space, and in particularly the right to peaceful assembly as a right that was extremely valuable at this time in history, but also very viciously attacked. Once that decision was made, we put in place a campaign. I thought this slide was absolutely a good reflection of how chaotic an organization like Amnesty can be. I'm not asking you to read this, but it kind of shows the combination of elements from, engaging with activists, we have grassroots, local groups, we have all these different elements that come into place when we take decisions about our campaigns and about the actions that we are going to take. And I'm just going to focus a little bit on the high-level objectives of the campaign, because one of them is pushing against the barriers to the exercise of the right to protest. We are talking of a right to protest which doesn't really exist in international human rights law, as you know better than me. But that was kind of a shortcut to speak of all the every time that was about exercising the right of freedom of expression and peaceful assembly as a way of achieving change. That's a bit so that you get a sense of how complex this whole thing is. As I said, we launched the campaign in 2022, and there's going to be a first stage of the campaign at least until 2027. We will not fix the issues affecting protests in these 5 years, but it is the first stage. We are continually reevaluating and seeing identifying what challenges. I think we are at a moment of the campaign where, as I was saying earlier, it's becoming quite overwhelming because we are in the global teams. We are constantly talking to our colleagues in the regions, working with colleagues in the Americas, which are facing terrible issues with policing and unlawful force during protests. We are talking to colleagues in Thailand who are really concerned about how children's rights to protest is being the specific challenges that children are facing to exercise their right. So it's in Europe, and it's one of the areas where I've been more involved and more familiar. It's absolutely fascinating to see how the narratives are playing when it comes to exercising rights and when it comes to enacting legislation. I thought an interesting example to mention was how in Italy the government enacted a law that was branded as against eco-vandals. So that was the public narrative around the law, that it was about eco-vandals. So yeah, it's I think it's a very interesting time in the campaign. I wanted to also mention a little bit the type of tools that we use in Amnesty's work, and everything is obviously grounded in research, but in research that has behind it an objective of achieving impact. And we do that through advocacy and lobbying, and then on the side of mobilizations and action. And additionally, something that's crucial for our work is strategic litigation. And we also work a lot, and this is quite a big thing for Amnesty. We work a lot on individual cases that we identify as emblematic, and that, by supporting a specific person, we can help achieve change for their community or in a more structural way. I wanted to mention a couple of concrete examples as well of work that is being developed at the moment and that is bringing up really interesting information. And one of that is our Observers program. It's a program where we are basically trying to support our offices around the world to develop their programs, to support movements on the ground, and to be able to document human rights violations, to stand in solidarity. It's a quite particular way of doing protest observation, because most of the time it's not specifically on the legal aspects to it, and a lot of the time it's around the campaigning that we do and the monitoring and of protests. And it's very interesting because we've been doing this already for many years. Now we are trying to find a bit of a more uniform approach as an organization, but it's absolutely fascinating how our colleagues, we're talking to colleagues in Kenya quite recently, how they had been able to do some protest observation and the limitations both in law and practice, but particularly due to policing and how observers are being targeted, means that at the moment it's absolutely impossible for them to go out and observe protests. I wanted to also mention, because this could be an interesting resource for people that are trying to get a sense of the legal legal challenges and issues. We created this digital mapping platform that is including information on countries about the situation of the right to peaceful assembly in terms of law and practice, and documenting some of the cases. I thought this could be one of the things that we're doing in the campaign that could become a valuable resource. I also wanted to mention, as an example of, because the campaign has some global calls, and it's very hard to identify those global calls that can be absolutely relevant and achievable. And I thought that because we've launched today this very interesting investigation, I thought I would just flag this piece of work, because it's absolutely I think it's really great, and it's a piece of work that I'm not involved in, so the credit goes to my colleagues. But we have a global petition, and we've been advocating in coalition with other organizations to achieve a treaty to regulate the trade of policing equipment, less lethal weapons, but also the equipment that should be just forbidden to be traded and produced. So I think it's one of the examples of the type of advocacy and objectives that have a global impact of the campaign. And then we also identify priority countries for some of the work that we do, and this works alongside all the national work that our sections are doing. And I wanted to finish with this image because this is a case, and obviously, one of our panelists will identify the flags straight away. It's a case of where it is very interesting because Greenpeace activists in Belgium organized this action of civil disobedience in a port, and they climbed these liquefied natural gas towers to denounce the violations that this company has been committing, and it's they've been charged with aggravated trespass, and they're going to be sentenced on the 15th of November. And I thought it was quite a compelling case for many reasons, because we were talking about protesting in the time of crisis, and a lot of the work that we're having to do on a daily basis in Amnesty is connected to climate justice. Activists in the Americas that go out and denounce violations in relation to the climate and the environment and their land are being criminalized when they protest and when they in the peaceful assemblies as well. But we see that in other parts of the world, and in Europe, it is one of the sides of the work, civil disobedience, that is keeping us very, very busy. And it's a good example of how the advancement of international human rights standards is giving us some tools, but the gaps in implementation are absolutely massive. And we are testing in real life cases how international law is working to respond to real life issues and it's very, very tough to support our colleagues in an activity in facing these challenges. I wanted to say a few last things. I'm going to stop the PowerPoint and you get to see my big head again. Just a few final thoughts about this. The fact that I think this campaign and all the work that the other panelists are doing is so relevant at this time, because it's not only that protest is crucial to challenge the different crises. Protest itself is in crisis. We are observing a crisis in terms of narratives. The fact that governments accuse protesters of all the things that other panelists were mentioning, being Marxists, being troublemakers, being vandals, and how this narrative is actually working in terms of the support of society more broadly to the right to protest, and how confrontations are being created by politicians between those that are disturbing the peace of complying citizens with their protests, and how is absolutely it is difficult to work on peaceful assembly and freedom of expression these days, and also a very crucial point that we're seeing in our day-to-day work in the law policy team is the stark contrast between all the advancements in international standards and the latest, for instance, is General Comment 37 on the right to peaceful protest, which is a tool that I use every single day for the work that we do, and that is recognizing things as civil disobedience, and the stark contrast with the practice of states, and not only the usual suspects, but also states that would normally comply with international law and standards, how we're observing that in Europe a lot, some countries that have normally a good reputation, how they are in the legislation that they're enacting and in the practices, in policing, how they are becoming some of the worst perpetrators. I just wanted to finish with just going back to how, on the one hand, it is overwhelming to see everything that's happening on the negative side, but also on the positive side, the resilience of the movements, the creativity of the movement is definitely a source of hope. And I also feel very hopeful in even in contexts like, and I refer to the UK because that's where I'm based, but you see how there's been legislation that is absolutely destructive of the right to peaceful assembly, but how we can erode that legislation by, through strategic litigation, through continuing our documentation and building up cases so that, change happens in the future. So it is a moment of crisis, but it is also a moment of hope.
Thank you. We have a good solid 10 minutes for questions or reflections from the audience. Yes.
Thank you guys for being here today. I was wondering kind of your perspectives on how to protect the right to protest in more informal situations. We've seen a lot in the past week, employers discussing kind of blacklisting protesters from certain movements. And I'm wondering if there's space for advocacy to protect from things like that, or if that's kind of going to become a backdoor way as y'all make advancements that the right to protest is diminished by large corporations or people with power.
Leo, were you able to hear that? Okay, so the question was how to protect the right to protest in more informal situations, including when employers and corporations blacklist people.
Well, I think that's challenging in the United States. There are, obviously, the First Amendment applies to government actors. So as a public employer, maybe you can make some arguments there, but I think that's going to be challenging with these kind of private corporations that you're talking about. I think I'll just say there's sort of an adage in First Amendment jurisprudence or the conversations of people who do First Amendment work, which is that just because speech is protected to some extent doesn't mean it doesn't have consequences. The right to free speech is not a right to speak free of consequences. And so when people use social censure, it can be problematic, but it is not, it also can be a really important vehicle for change. So it's complicated, but from a legal standpoint, there's not much that can be done about it. I think specifically what you're talking about, if I understand the question.
So in a non-legal response, one of the things with SLAPs in particular is that there are SLAPs that are filed every day, and they're filed usually against people who are just fighting for survival, like developers who come into communities, threatening water, this and that. And so most of them don't get, are never heard or never known. And we've been working a lot with different, community leaders who never saw themselves as activists, but sort of took this on. And one of the common things that has come up is, for the ones who have been successful, what was the turning point? And it was visibility. It was getting the message out. It was, a lot of them were lucky to have, maybe a New York Times story, but even if it doesn't reach to that, there's there's something to be said when the story becomes visible. It is the other side that all of a sudden, their position, not always, but often changes. It's whether it's the law firm behind it, whether it's the company, whether it's the employer, they're vulnerable to that. So, when the ask is to continue like being bold, making noise, we need to make these instances visible, because as long as they remain invisible, I think that the practices will continue.
Leo, do you want to add anything?
Not entirely sure I understood the question, but it was in relation to companies, right? To private actors.
That's right.
Yeah, there's an increased recognition in international human rights law of the responsibilities of private actors. And I think even with the right to peaceful assembly, General Comment 37 recognizes that some days it is possible to exercise freedom of assembly and disrupt and do it in private property, or do it in a way that can be considered to disrupt private entities or broader society. So there is a recognition, also partly because a lot of the spaces that would allow the principle of sight and sound to be realized are private spaces. We had activists recently in South Africa staging their protest in the hall of a bank, and the bank has some obligation to allow a protest that is within some parameters to happen. So I think there's some evolution in that direction.
Other questions? Olivia?
I was wondering if, and thank you so much for coming here to talk to us today. I was wondering if in your experience at your organizations, have you had cases where you've protected the right to protest on digital platforms, like on social media? I think that happens less now. I think people, especially during 2020, people were finding ways to protest online on different social media platforms. I was wondering if you've been involved in that kind of work, and if you have, how is that different from protecting the right to protest in person?
So the other question was whether or not whether these organizations have worked on protecting the right to protest on digital platforms, including social media, and how that might differ from protecting the right in person.
Well, we haven't necessarily been involved in protecting. We're on the defense side. So, I mean, it's pretty incredible but these hundreds of $1 million lawsuits are, the basis of them are tweets, blog posts, just republishing statements that were widely disseminated in the public. And so it is obviously a very growing area of the law, but we're on the defense and hopefully going to make some good law on those issues.
So this comes up a little bit in the context of people who want to sort of tweet at public officials and then get blocked by those public officials. And there can be some First Amendment issues we've seen with that. And so I think this is a critical issue to work on, thinking about how various internet electronic platforms really are our public squares of today. And are becoming these public spaces, even though they're controlled by private corporations, and what can you do about that? But I think there are points of entry when you have public officials, using these platforms to make their views known, and when they try to shut down dissent. That's the avenue that we've usually worked it from.
Yeah, I think it's a fascinating area where we haven't, I think we're quite new in exploring even the definition of what is an assembly online. It's easier with freedom of expression online because it's very similar in terms of the standards that apply. But it's really fascinating. It is recognized in international human rights law that peaceful assemblies can happen also in the virtual space. I don't think we have much practice on what that means and what it represents and how to protect those rights in a different way, because we are quite still linked to, we see it more when what happens online has an impact on real life in terms of, surveillance of people that are planning to organize protests, in terms of, how people organize online and because they are planning online, they are being detained in real life. So we see that a lot, but there's a whole new dimension of assembly online that is going to be unfolding in the years to come, and we need to get ready for that. Again, freedom of expression is clear. As I'm looking, we've done a lot of work on protection of women and LGBTI people and racialized people on online platforms, and highlights the responsibility of big tech when it comes to making those spaces safe. But then again, on assembly is going to be a very interesting time to observe.
Thank you. We're just about at time. So again, a huge thank you to our three speakers and for everyone for joining today.